President, State of Ohio versus Louis Marconi, case number 22-CR-607. Defendant is in court represented by counsel, and we are here today for purposes of sentencing. We were last in court on October 20th of 2022, where the defendant pled guilty to count 1, theft, a felony of the 5th degree, and the court referred the defendant for a pre-sentence report, victim impact statement, drug and alcohol evaluation, continued bond, and
we're starting with a 5th degree felony theft, lower level felony, yes. But sentencing is where judges zoom out and look at the whole picture. The pre-sentence report, drug evaluation, victim impact statement, that's the court gathering receipts. This isn't just about what he stole. It's about who he is on paper. And that's about to matter a lot.
Scheduled sentencing for November 28th. On November 10th of 2022, the defendant's bond was revoked after he provided a urine sample that was not valid, and then a subsequent sample that tested positive for buprenorphine and tramadol. And then on the scheduled date of sentencing, the defendant failed to appear as well, which another warrant was issued on that date. The defendant has since been apprehended, and the state's prepared to proceed.
A fake urine sample, a positive drug test. Then he skips sentencing entirely. That's not just a mistake, that's compounding damage. Judges take failure to appear very seriously because it signals one thing: you can't trust me to follow court orders. If you're the judge, are you thinking probation or consequences?
With sentencing.
Thank you. Mr. Watson, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Thank you, Your Honor. May it please the court, I'll be brief. Mr. Marconi simply has no excuse for what he did, Your Honor. He knows that he did a change of plea over 2 years ago. He did show up to probation. It was there that I learned.
He did show up to probation.
He did. Okay. He did initially. And it was there that he submitted a false urine sample because he knew that he was going to be positive for drugs. He knew that he was going back to jail, and he was scared. And I know, Your Honor, that's no excuse for what he did, but he did that, and then he absconded. He failed to appear for his sentencing on this particular case. And for the last 2 years, I mean, he's been living with his mother, his father. I've spoken to his mother, and I know he's got some troubles, Your Honor. Not only troubles with drugs, obviously, but he also has some mental health problems. I'm going to ask the court to consider imposing a minimum sentence on this case. I know that the case is older. If there's one redeeming factor outside of the failure to appear, because he was out on an OR bond, he has not picked up any other cases, to my knowledge. I'm going to ask the court to consider imposing a minimum sentence in this case. Thank you, Your Honor.
Thank you. Mr. Marconi, you have the right to address this court before your sentence. You can say anything you'd like. Is there anything?
This right here is allocution, the defendant's personal plea to the judge. This moment can absolutely change a sentence. Judges listen for accountability, not explanations. Ownership, not blame shifting. The tone here? It's everything. Let's see if he leans into responsibility or into excuses.
What do you want to say at this time?
I just wanted to say, the personal judge, as far as the failure to appear, the thing was, I just got scared when it happened. I gave the probation department a fake sample of urine. Now, even then, when the day it happened, when she asked me about it, I didn't lie to her. I didn't want to start. I even told her I don't want to start off the wrong foot with you. You know what I mean? Yes, I did give you a false sample because I was dirty and I knew they were going to put me in jail. However, I just, all I wanted was ask. From what I'm being told, it's not possible. But jail's not the answer for me. Okay, I came a long way from now until my whole life, really. And all I was asking for was a chance. I screwed up, throw the book at me, man. All I was asking for was a chance at probation. I feel like, to me, that's direction, in my life. I just finished 3 years of community controls, okay? And I'm sure you guys could probably
When did you
verify
finish,
that.
where'd you finish 3 years of community control?
Right here in Painesville. I was Ronald Downs.
You were what?
I was on community control with Ronald Downs. I never one time failed a dirty urine. I was clean the whole
When?
time.
When were you on probation?
I was on community, or not community, well, it was, I don't know what they call it. Is it called community control and
In
parole?
municipal court?
It was in parole, I'm sorry. I thought they called it community control.
This is community control. You're on
Okay,
probation
okay.
here.
I have it. I was on parole, but I thought they called it something else.
He was on
They call it
post-release
post-release
control.
Post-release control, I'm sorry, I'm so sorry. I mean, I just did 3 years of that, no hiccups. I mean, I was clean the whole time, you know what I mean?
You weren't clean when you got arrested.
I've done everything these people told me to do. Now, I was taking drinks from, they said that was dirty for something else, marijuana. Now, it could have been through drinks that I was taking, fresh water. I mean, they have a lot of different things out there nowadays, I don't know. Only drugs that I use is marijuana to this current day, which was very...
When you were arrested, you were positive for methamphetamine
Yes.
and amphetamine.
Yes, and I was doing that prior to some time ago, but they have drinks out there now.
No, you tested positive just like 2 days ago.
I understand what you're telling me, Judge. What I'm telling you is they have drinks out there now they'll make you test positive for stuff
No,
like
they
that.
Oh no. This is a dangerous courtroom moment. When a judge directly says, "Not with our testing," that's a credibility check. And credibility is everything at sentencing. Once the judge doubts your honesty, your chances at probation shrink fast. Be honest. Is this helping him at all?
Now with our testing.
Okay, well, I'm telling you, I don't use anything else other than pot. I haven't.
We're
in
positive for
months.
marijuana.
I was smoking marijuana the morning we got arrested in my driveway. When the cop pulled up, just the morning we got arrested. What I'm saying is, I was just asking the court for a chance at probation. You know, that's it. I wanted to make this whole big thing. I'm not lying to you about the drink. I don't know as far as what they had, whatever. I don't know how there couldn't possibly be marijuana in my system. You know, I feel like that would be direction for me, you know. And maybe I need more direction, you know. I did the 3 years post-release control, you know what I mean? And I got off and, you know, maybe I wasn't ready, I don't know. I just feel like jail's not the answer for me. You know, my family needs me at home. I need to be at home with my family. You know, this has been haunting me for a long time because I couldn't get an ID. I couldn't do anything ever since I had this warrant from November of 2022. And, you know, I don't want to
You turned yourself in.
Well, yeah. Like I said, I got scared, and sometimes it's easier said than done. I don't know if, I'm sure you can understand that. Like I said, you know, I'm being as genuine as I can with you. Like I said, I don't feel like jail's the answer for me. And I was just asking for a chance. I mean, that's it. All I was asking for. I mean, if you look at my priors, I've never not failed to appear. You know, I had no intentions on this even dragging out this long, honestly. You know, it's just my mind playing tricks on me, saying that I was gonna, you know, do something, and I never did. You know what I mean? My whole plan was to turn myself in a long time ago. My mother, my father, everybody tried to get me to do it. You know, they couldn't make me do it. Well, that's really all I got, Judge. You know, I can't sit here and plead and cry to you. I was just asking for a chance. That's it. You know, I was asking for a chance at probation. I can promise you would never see me again. And I'll do the probation. I'll do whatever you guys want me to do. I'll do it. Thank you.
Mr. Watson, anything else?
Nothing further, Your Honor.
Mr. Leshy, for the state of Ohio.
Thank you, Your Honor. The state is requesting prison. The defendant has a lengthy criminal history involving drug offenses, but also theft offenses, similar to what he pled to in this case. He has 6 prior cases that resulted in 4 prison numbers, and even the defendant's conduct in this case has clearly demonstrated he would not be amenable to any community control sanctions, and that prison would be a
6 prior cases. For prior prison terms. That's a pattern, and courts call that recidivism. Under Ohio sentencing law, prior prison history makes community control much harder to justify. The prosecutor just framed this as, "We've tried giving him chances." That argument hits hard.
appropriate. Thank you.
Keely, are you aware of anything with this PRC?
I have no updated information, Your Honor.
This court has reviewed the pre-sentence report and investigation. There is no drug and alcohol evaluation because the defendant didn't show up for that. I've considered the facts and circumstances of the underlying offense, the nature of the offense. I've considered what's been said here in court today. This is all considered by the court in light of the purposes and principles of felony sentencing set forth. I have considered all that foregoing in light of the purposes and principles of felony sentencing set forth in 292911 of the revised code. I've also considered the factors in 292912. Factors indicating the conduct is more or less serious. Nothing stands out factually about this case indicating any of those factors are present. As for recidivism factors, almost all of these are present. The defendant has a lengthy, very extensive history.
Excuse me, Judge, just, when I use, I get in trouble. I mean, just what happens. I apologize. I'll burst.
Can I speak or?
No. Defendant has a lengthy criminal history as well as juvenile delinquency adjudications. Goes back almost 29 years now. When he started as a juvenile and then continued as an adult and just year after year. He has not responded favorably in the past to previously imposed sanctions. There are multiple probation violations in the past in his record as well over the years. He has served multiple prison terms for multiple cases. He has violated the conditions of his bond. He failed to appear for his sentencing and was gone for over 2 years. He was arrested. He tested positive for drugs. No factors indicate recidivism is less likely. In 292913B1, the court finds the defendant has previously served a prison term. Prison is consistent with the purposes and principles of sentencing, and there's no way this court can make any finding that the defendant's amenable to available community control sanctions. I made a comment that if I put him on probation, I'll never see him again. I never saw him after when he pled guilty. I never saw him again.
So,
He can't assure that he's going to do anything when he's on probation. Therefore, it will be the sentence of this court that the defendant serve a term in prison of 10 months. He has
10 months in prison. Not the maximum, but not probation either. Notice how the judge walked through the legal checklist. Seriousness factors, recidivism factors, prior sanctions. That's textbook sentencing analysis. In the end, this wasn't just about theft. It was about trust, history, and whether the court believed change was likely.
credit for 12 days he has served. He had 1 day of credit initially, and then he's been in for the last 11 days. You need to advise you upon your release from prison, you could be placed on post-release control in this case for up to 2 years. If you are and you're violating those conditions, the parole authority can send you back to prison as punishment for violating their rules for another 50% of the maximum term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. The defendant's ordered to pay all costs. Is there any restitution issues with this?
Your Honor, as part of the plea negotiations, I had informed the defense attorney at the time that the bank had reimbursed him for the amount of money. The only thing he was at was the cost for a new driver's license, which was approximately $26.
Order restitution to the victim amount of $26. Is there anything else, Ms. Alessi, for the state?
No, Your Honor, thank you.
Mr. Watson?
No, Your Honor.